Gainesville, Florida is a small, peaceful town in north central Florida, known for its colleges, performing arts center, museums, and most importantly, the Florida Gator football team. In the fall of 1990, Danny Rolling disturbed that peace by brutally murdering 5 college students: Sonia Larson, Christina Powell, Krista Hoyt, Tracy Pauls, and Manuel Taboda. Gainesville will never forget. This is his trial. Good morning. I don't know why I am so sleepy this morning. Okay, so we have Danny Rolling's sentencing hearing, and it is going to be about 2 hours. And then this afternoon at 12:30, I'm going to be live streaming again the motion for a new trial in the Ashley Benefield case. So let's go ahead and get started with this one.
Previously announced was the jury's version. It was an opportunity to understand the council presentation on that report. For considering prior versions.
Oh Lord, the sound.
Thank you, sir. The court has indicated to counsel that it would entertain additional information for the purposes of sentencing review. And at this time, I would offer to the court 1993 at the Cato Parish Courthouse in Shreveport, Louisiana. The state attorney's office also has a copy of the deposition of the present court, and also the deposition of Harvey May Stroger, taken on December 2nd, 1993 at the Cato Parish Courthouse in Shreveport, Louisiana. Once again, the state attorney's office also has copies of that. In addition to
And again, I apologize for the tech issues. It's StreamYard. Other people have been having trouble with StreamYard. It's not just me. Last night I was watching a live with Nate the lawyer, and he comes on and he says, "Okay, we're live. I think we're live." And then he just disappeared. And then he came back and he was like, "Okay, well, I thought we were live." He goes, "StreamYard has been giving me problems all day." And that was yesterday, the same day I had trouble with StreamYard all day. So it's not just me.
in case number 90-2111CF-A-X concerning aggravating circumstances prior to crimes of violence. The state introduced a number of convictions from Marion County involving Mr. Rowley. Those cases are currently still on appeal, and we would serve to the court notice of the fact that those cases may be open, then the have to present a copy of the statement.
I've about had it with StreamYard. It worked fine before I paid for it. I started paying for it, it started freaking out on me. Oh my gosh. I promise y'all, before the Sarah Boone trial, I will be hardwired in, because if that's the problem, but other creators are having problems with StreamYard too. And EDB said that after it changed ownership, that she started having problems with it. So, and she's on the, I don't know what they call it, like on the board or whatever. Like, I don't know. She has like voting rights or something. Hopefully, she can get them to fix whatever's happening. I don't know. So we were talking, because my computer is an all-in-one. So my husband and I were talking about it last night, maybe taking the computer into the living room where I can hook it right into the router, since it's not, a bulky, tower and everything. But since this is the last day of the trial, and I'm not going to be excuse me, I'm not going to be live streaming anymore until Sarah Boone's trial, I don't think. I decided not to worry about it for today. So, yeah, cross your fingers. Well, dang it, I forgot to share my screen. It would work better if I would share my screen.
Make a presentation to the court will be Mrs. Claudia Rowland. Claudia, if you have anything you wish to say to the court at this time, I would ask you to please address the court.
Your Honor, I would first like to thank you for the opportunity to speak in behalf of my son, Danny. And I would also like to tell the survivors of the victims that although I've not said anything, my heart's been with them. I felt their pain, and I pray for them. And I hope that with the closure of this case, they'll find some closure in their lives and be able to go on with it. 39 years ago, almost 40 now, the Lord gave me a miracle. Why? When I held this little baby in my arms, I had no idea, no thought that he would be anything except a doctor or a lawyer. I watched him grow. And at a very young age, changes that ultimately brought about the horror that we've gone through in the last 2 or 3 years. I'm not asking for freedom for my son. The only one that can give him that is my Lord and Savior and yours. But I beg, I cannot imagine that taking one life will bring others back. And I want my son to live. I don't see him as other people see him. I'm a loving, gentle, kind little boy. that grew into a young man. Danny never really went past the age of 15. He stayed a child, and he's a child yet. Your Honor, I had so many words planned out to say to you. I guess the most important thing I could say find mercy somewhere in your heart that my son might live. I have prayed that if the death penalty is upheld, that my Lord will take him home in a gentle way.
I'm sorry, but he deserves to be taken out the same way his victims were taken out. And I know we can't do that. He gets to go out humanely, but he needs to be taken out just as bad.
Would say he deserves it. That could very well be true. But I'm a mother, and I love him. And I don't want him to hurt anymore. I felt it deep in his eyes. You could swim in it. And he tried to carry it and bear it on his own.
It said my sound got disconnected. Can you still hear it? Can you hear the video? Oh, it wasn't letting me show comments a minute ago either. Yeah, Grimm's fairy tales are gruesome. Okay, hang on.
Grew up with a mother that was weak. If I took care of things for me. My boys took my mother and father's place, and they took care of things for me. They protected them. Once again, I say, Your Honor, I see my own life.
The next presentation will be by Charles Stead.
Ever since he was up in his late teens, he was good, caring. He loved everybody. He loved to get out in the open. He loved the animals. If he seen a little old dog in the street, he'd try to get it out of the street. He used to come to my house and sit and visit with me, and talk to me. He'd come by when he was trying to find work, and I helped him get a job a couple of times, and he worked and done his best. He used to come and sit in my house and play his guitar and talk to me. There was always something. I have 3 children of my own, and I work with children, church and daycare center. And I could tell something was missing in Danny's life. He'd sit and tell me, we just don't talk. And I'd come down here and sit and talk with you and visit down when I had my open heart surgery.
I'm getting aggravated now.
Fine. Come and sit with me. And he always told me how much he loved her too. He tried to explain to his dad sometimes about why, if he could find a job back home instead of being, and when he did, he'd sit and listen. But Danny never said a bad word about anyone. He never spoke ill word towards anyone that I ever knew, speaking bad about anything or anybody. He always had a smile. He'd come by day or night. He'd come by the house. He never failed to stop, check on me when I was at home. He was so loving and caring. People I talked to always known Danny, said he was a good boy. He loved the Lord. He talked about the Lord sometimes with me. He'd sit with me and bring his guitar and play his guitar and sing songs. And I loved Danny. He seemed like he was so caring. He just had so much in life to look forward to. I don't know why things are like they are. He wanted to so hard. One thing it was missing, and he wanted his father to love him. That was lacking. He always said, every time he come by, I just wish I could talk to my dad like I talked to you. I tried to talk to him like I talked to my boy. I considered him one of my children. I'd ask him if he needed money. Sometimes he'd come by and I'd sit and eat dinner with me. Or he'd come sometimes and eat supper with my wife and I. I never do it to mistreat anybody. Come by, just always come by. He just had to talk to somebody. He just didn't have nobody he could go to and talk to like his dad. Like he could come and talk to me. I always asked him how I was feeling. If I wanted to get out, I told him if I couldn't get out, I'd tell him no. And sometimes he'd come out and we'd walk in the yard. But I've seen time he'd come by and he'd be going home. One occasion he'd come by and he'd walking home in the rain, and I stopped and picked him up. I said, Danny, I said, where are you going? He said, I'm going home. I said, why, Danny? Were you walking? I said, you know to stop by my house and I'd take you home, but I didn't want to bother you. I said, but you do anyway. He said, well, I can't go home right now. I said, why, Danny? He said, my dad goes to work tonight, and if I go in and wake him up before time to go to work, he said, he won't like that. I said, well, you come on in the house and eat supper with us, and you can stay here a while. And he come in and stayed. I think that was the last time I saw Danny. I tried to help him like I did my kids. And all the young people, I tried to give him good advice. And he listened. He just needed somebody to talk to. He'd pour his heart out, tell me how he felt. He'd sit and pick his guitar and sing. He said, I wish I could do this at home. I don't know why things are like that, why it's turned out like this. I don't know where I'll ever see Danny again. I love Danny just like a son. He always told me how much he loved me when he'd get ready to leave. He'd say, now you be careful and take care of yourself.
You
It's okay, Charles. Okay. Thank you for your presentation, Charles. We really appreciate it. Okay. The next presentation would be by Mrs. Agnes Mitchell.
Oh, yeah, to get the vehicle.
Ms. Mitchell, this is your opportunity to make a statement to the court concerning your feelings about your nephew, Danny Rowland.
Your Honor, I'm Danny's aunt. And first I want to say that my sister's testimony was pretty close to my heart. And I'm feeling the same things that she felt, because that boy grew up almost in my backyard. He was almost like my own son. I took care of that boy when he was just an infant, on up and seen him grow into a teenager, and then on into a grown man. And I knew that Danny had problems from an infant. And we tried to tell their parents that he had problems. But as parents go, they thought that he would grow out of it, or I don't know what their real feelings were about it. But nothing was ever done for Danny. And I'm saying now that my sister took blame for things that she was not guilty of. She was a good mother. She took good care of her boys. But she was forced to hover them from their father. Their father was cruel to them and was very abusive to them. So she was forced to stay closer and more protective toward them. And I wanted to say that the Lord took Danny and was making a good man of him. He became a Christian and done a lot of Christian work, and we were so proud of him. We thought that all of his problems behind him was going to go away, but they didn't. There was still something in his mind that kept changing him from one thing to another. And he began then to get on the run. And he used to tell me, "Lady, there's something that's just pulling at me. There's something that's forcing me to do things and to have ideas that I've never had before." And I would say, "Danny, what are you talking about?" He'd say, "I have feelings like my family don't love me. My daddy does not love me. And my mother is to the point she can't protect me from him anymore. He says, I love my daddy, but he won't talk to me. He keeps telling me that I'm no good and I will never amount to anything." He said, "How can I prove to him that I want to be good and I want to amount to something for him?" He says, I've sat down and tried to think about it and think what I could do to make my daddy love me. He said, I wanted his love so much. Well, Daddy worked for me even after he grew up. But like Charlie said before, he used to come and have long talks with me. I used to take him on my job and ride him up with me for a day, pouring out his heart to me. It seemed that Danny wanted someone just to listen and do something for him, that he could just come out of a shell or something and just be okay, and everything would be all right anymore. But I kept seeing changes in Danny from year to year that would disturb me. One day he might be fine and happy, just happy-go-lucky, and maybe the next day he was disturbed and couldn't seem to make up his mind what he really wanted to do. But he would always grab that guitar and come to my business and sit there and play. And all my customers in this business loved him. And when all of this business happened about those murders, they couldn't believe it. They said, Danny couldn't have done that. He's not that type of person. He's too loving a person.
They all say that.
So, Your Honor, I'm begging for mercy for my nephew, because in my own heart, I don't see Danny as a murderer. I don't see Danny as the type of person who could take a life of anyone or anything. He always loved his pets. He always was very protective of his mother and his brother. He was always protective of me. He would stay with me at late night till I closed my. So, Your Honor, I'm asking for Danny's life. I don't want him to die. I want Danny to be like I always wanted Danny to be. I have so much feelings, so much sympathy for those parents that have lost their children. Well, I know what a terrible thing it is. Your Honor, I see that. So, Your Honor, I'm asking mercy. Have mercy. I know the Lord can deal with a lot of situations. Please pray about this. Let's pray about this, Judge. What to do about Danny, but please have mercy.
Thank you, Ms. Mitchell. Appreciate it. The next presentation will be by Mr. Kevin Rowland.
I asked you, I'm not sure which. We could all beg mercy, but I'm not sure that it'd help. I do hope this, that what you can hear when you make this judgment is not the law or the crowds, but I hope you hear the voice of God. And if he tells you to be merciful, then I hope you follow that what he says. I hope he's with you when you make your judgment. And I believe he will be. That's all I got to say.
Okay, thank you. Next presentation will be by Mrs. Artie Mae Stroger.
Thank you for giving me the time to plead for my nephew's life. He was a good boy. He was honest. All he wanted was love. He loved everybody, and as far as I know, he was a good boy. He always showed me love. You could tell him you loved him, and he'd say, "Do you really love me?" I don't think he heard that too much. Excuse me. And I want you to know my heart goes out for those families that have lost their children. I have prayed for them. And I pray for Danny, so please spare his life. We love him. And I want to thank you.
The next presenter would be Mr. Charles Stroger.
Your Honor, I've been knowing Danny since he was about 6 years old. And this is really hard to, I guess, if the question was asked, the main subject would be, did he know right from wrong? And I don't believe Danny really ever knew right from wrong. Not any length of time, because I believe that most of his life, he's never really had any kind of structure, as you know it and as I know it. That his life was broken in different ways. That Danny never had any concept of right and wrong. That he lived out his life in a play. And anybody that's not mentally capable of thinking and being rational, I believe does not deserve to be put to death. To me, it's not right. It's an act of vengeance. I feel for the victims and their families. And if there's any way possible to sway your decision because of the viewpoint of the jury, I would hope you would do so. I feel that Danny is...
I have thoughts. I'm sorry. I've been trying not to pause it too much because it seems like when I pause, that's when it goes kind of wonky. But I have thoughts. I'm sorry. I have thoughts. When it comes to unaliving people, everybody knows that's wrong. The only time that you can say that they didn't know right from wrong when unaliving someone is if they are so delusional that they don't know what they're doing. Like, that they think that it's not a person. That's the only time. He knew they were people. He knew he was essaying women. He knew exactly what he was doing. And not only that, he told them he wanted to kill a person for every year he was in prison. That's not just wanting to essay and unalive. That's revenge. And it's not even logical revenge because those 5 people didn't do anything to put him in prison. So that makes no sense. Of course he knew it was wrong to do what he did. I don't care how messed up you are or how messed up your childhood is. You know it's wrong to unalive another human being. I have said this so many times because for me, I'm claustrophobic. Now, the cells, I don't know, even maybe the cells with the bars that you can see through, they seem, even though they're not open, they seem more open because they have the bars where you can see. But I was watching a documentary on, I can't remember if it was Netflix or HBO. It was the guy that was in love with the cam girl and he sent her a bunch of money and stuff, and he ended up killing his family because his twin brother and his parents, because they had cut off his money and he couldn't send money to the cam girl anymore, and he told him that he had to break ties with her or whatever, and he ended up killing his family. And the documentary was this journalist that was like basically following the case, those kind of crime documentaries are. And it showed his cell and it had a door it had a little window in the door, but it was a door. And that room was so small. And I remember thinking, I got claustrophobic watching it. And I remember thinking, if I had to stay in a room that small for the rest of my life, I would go insane. There's no way. I would be like screaming and throwing myself against the door trying to get out of there. I would just go nuts. So, yeah. And I've always there was an episode of Law and Order once where the guy was like, "Okay, I did it, but I want the death penalty. I will plead guilty if you give me the death penalty." And I was like, "Yeah, straight up. I agree. I'd be the same way." I would rather die than be in prison for the rest of my life. I agree. Totally.
And that's my knowledge of growing up with him. He's never had anything that we would know as a structured life. He never had opportunities that you had or that I have. And making a decision to send him to the electric chair, I believe, would be a harm to humanity, breaking the Lord's law. And the only time I believe that something like this would be justified would be during war. And not to take the life of someone who is mentally ill and who is not capable of thinking or knowing right from wrong. That's all I have to say.
Thank you, Vincent. Next is Miss Sue Stedham.
Your Honor, first of all, from having known Danny, his mother, father, and Kevin, my life has been richer. I feel sympathy for the families that are left grieving. I also feel sympathy for Claudia and her family. I've been through a lot with Claudia. I love her like a sister. Many, many times, when Claudia didn't know where Danny was, I had perhaps taken him to Daddy Walters and Mom Murdy's. He was the loneliest person in the world, as he told me so many times. All he wanted was approval from his father. No matter what I do, Danny told me, my dad never approves. Danny's the sweetest, kindest, gentlest person I've ever met. He's visited with us many, many times. That sweet, gentle, kind voice. I love you, and I appreciate you. Your Honor, if you could find mercy in your decision to save Danny's life. Thank you.
Thank you, Ms. Stedham. Appreciate it. Listening to the advisories, and you all arguments made in behalf of all those motions and objections that we require in the course of trial.
Your Honor, I only addressing the motion for the new advisory sentence hearing. I think those matters are all matters that are being preserved. Those are matters that have all been raised previously. The state, rather than address each of them individually, would incorporate and reassert all those arguments that were earlier raised and ruled upon by the court, both during trial, and most of these, Your Honor, I think if you review this, you will find were matters that were raised in either the pretrial proceedings of the Fourth, Fifth, and Sixth Amendment that Your Honor conducted substantially prior to trial and affected the evidentiary presentation of the case. I have nothing new to add to as it pertains to this motion. I would only reassert and reallege those matters. I understand the defense may have something further before they give up their time at this moment.
Yes, sir, I believe at this time, Your Honor.
I'll wait till they complete.
Mr. Hall also wishes to make it short, taking the report.
Oh, is he gonna talk now?
Reading, you come around.
Yes, sir. There's much I'd like to say, Your Honor, about our world, my beliefs, and the destiny of man. However, I feel whatever I might have to say at this moment is overshadowed by the suffering I've caused.
Yeah.
I regret with all my heart what my hand has done, for I have taken what I cannot return. If only I could bend back the hands on that ageless clock
If he breaks out
and
in
change
song,
the
I'm
past.
done.
Ah, but alas,
Oh, but
I am not
oh my God.
the keeper of time, only a small part of history and the legacy of mankind's fall from grace. I'm sorry, Your Honor.
Not at this time, sir. I believe Mr. Park will have one motion he needs to present as a matter of law to the court at the conclusion of the proceedings.
Please, Court, Your Honor. As the first matter of business for the state, as I advised the court this morning, the state will be filing what I have characterized for purposes of its presentation victim impact statements. I would announce to the court, however, that these victim impact statements are non-notarized statements that are not being filed pursuant to the amendment to the statute, as I have announced both to the defense and to the state prior to making these presentations. It is the view of the state, Your Honor, these are statements, however, that should be proffered into this record for that which the court deems appropriate under both the current state of the appellate law and the current state of the questions of constitutionality as it pertains to the recent amendment on victim impact statement. These are not being submitted, to be very clear for this record, both now and in the future, pursuant to any victim impact amendments to the statute. These are simply being submitted as we would in any case where victims have had losses and wish to address their judiciary. The state both recognizes and is advising victims of what limitations this court may place on their usage, but I think it's appropriate. It's an appropriate exercise of any victim's rights to be able to address the court as a matter of sentencing. Much is made of the rights of people at this phase being less defined, and I'm clear that they are less defined, but I would like to go ahead and proffer these in Your Honor. I will be submitting impact statements from Ada Larson, the mother of Sonia Larson, Beth Devitt, the sister of Sonia Larson, Ricky and George Paulus, the mother and father of Tracy Paulus, Patricia and Frank Powell, the mother and father of Christina Powell, Barbara Melton, the sister of Christina Powell, Nancy Bundy, the sister of Christina Powell, Frank and Tessa Powell Jr., the brother and sister-in-law of Christina Powell, Teresa Ann Guerin, mother of Krista Boyd, Servando Carriega, the best friend of Manuel Pagoda, Diana Carriega, the wife of the best friend of Manuel Pagoda, and though I don't have it with me this morning prior to sentencing, I will be filing a copy of an additional letter, which is from the Diana Hoyt, Your Honor, on behalf of Krista Hoyt. So, having said that, Your Honor, I would proffer these into this record. We would please to file the additional document from Diana Hoyt.
You have to leave off the document. What I'm going to do is direct Clerk Marcus and consider for identification. They will be part of the record. I discussed this with counsel, of course, reviewing the interplay between Article 1, Section 16, the Victims' Rights Statute, Payne versus Tennessee, the 18th Amendment provisions. And I will address the treatment given to these exhibits, if any. sentencing.
Your Honor, a couple of other administrative matters. The state will preserve now, as notice of court, that we will be filing motions for restitution both on and costs of prosecution. Those will be filed both on behalf of the victims' families to the degree that the restitution statute is applicable and to the degree that costs of prosecution are recoverable, both of which I think have substantial potential in this case. The state will be in conjunction with Alachua County Attorney Mary Marshall having indicated that their wish to provide us with additional documentation. We will be filing prior to sentencing or at sentencing the motion. And I think, Your Honor, if I recall, the cost and restitution issues, we would be asking you to preserve those for purposes of having an independent period and issuing the order within the time frames provided for in the statutes. The state would also, Your Honor, notify the court that we will still be proceeding on the issue with Mr. Mills. This is not so much for the purposes of the defense, but we still need the court to set a date certain for the hearing of the issue regarding the release of certain items, primarily photographs that depict brutality to victims. I don't know if Your Honor is aware of that entire package, what we're talking about there. We still have that hearing, and I know that we've had some inquiry about that. That probably needs to be done at or before the time of the issuance of the sentencing order. So I think we'll probably want to package whatever goes up to go up together. Finally, Your Honor, the state has no further arguments to advance to Your Honor other than those things which were addressed to the jury. In response to Mr. Kern's presentation, I just would very briefly add that I think that of all the duties that Your Honor undertakes when you choose and are for the judiciary, and of all the duties which a state attorney undertakes when you choose and are permitted to be state attorney, that which is the one we most wish to avoid, at least welcome as part of our duties, but is the one that you are facing now. We have a very specific process of law. You have a very clear advisory sentence. It was a hearing in which Your Honor, I believe, gave every opportunity and latitude to the defense for presentation to the advisory jury of those materials which would be appropriate for the consideration. I think the advisory recommendation of the jury is one in which their sentiment is overwhelming based on the gravity of what we're dealing with here. As I viewed these materials this morning, it seemed to me to fly in the face as much as what we heard before, because here's a person who obviously had lots of support, lots of family, lots of opportunity, and threw it all away. And in throwing it all away, chose a life of that, the result of which brings him here. It's a duty that Your Honor doesn't welcome. It's a duty and a responsibility and a covenant that Your Honor has been both blessed with and cursed with, depending on the day. But it's one in which we have every confidence in Your Honor's will, that Your Honor will see the duty clearly, will read the evidence as plainly been, and recognize that Danny Darrell wrote to all the people that stood in this courtroom over the years of this courtroom and when it was across the street, Your Honor, practicing there, of all the cases that have ever been here, Danny Darrell has earned his sentence more than anyone that Your Honor has ever seen. And I know that Your Honor will heed the advice and give it great weight, as Your Honor has told us to do, as advised. The jury so many times will give it great weight. This is not an exercise. Days of our law. And I think the mandate of that jury, to the degree that it is advisory to you, which it is very clear. Nothing that's occurred here today should at least change the sentencing from that which was recommended. Thank you.
Harper, is there something about it, something in 2003?
Yes, Your Honor, this, as a matter of law, I have filed with the court a motion for fees and costs. This is something for you to consider between now and the entry of your final sentencing order. The motion sets out two different categories in general, one legal attorney's fees and the other the reimbursement to the county for costs that are statutorily specified. Those amounts are listed in the motion. If the court requires a detailed accounting, certainly that's available from county government. The issue of inability to pay, of course, is one that the court will have to weigh in the decision of how to deal with the request. Also, you'll notice that Mr. Rolling has signed the motion acknowledging that he is aware that I have filed the motion and is also aware of his rights to contest the matters that the court may decide. For the purpose of aiding you in drafting your sentencing order, Mr. Rolling I would request a hearing specifically on the imposition of any fees or costs if the court elects to do so. On the other, I mentioned cost is statutorily required and specifically listed in the motion. On the fees, there are a couple of points I would just like to make. The first is that for all purposes relating to the public's knowledge, I know you're aware of this, but certainly for all purposes relating to the public's information and knowledge about this particular motion, none of that money comes to either the public defender, the assistant public defenders, or any staff employed by us. Each of us are salaried employees, paid the same whether we're handling Mr. Rolling's defense or any other office assignment. Not only are there no bonuses for anyone involved in handling this case, but no compensation for the many hours of overtime that have been invested. This money would simply be, if decided by the court, paid to the county to help offset their costs of operating the court system. The figure that I put in the motion as a reasonable attorney's fee, I would like to emphasize to the court, is strictly an arbitrary figure. The methodology that I employed in arriving at that estimate is to try to estimate the number of hours worked by the attorneys, but only by the attorneys, not investigators, and not by the support staff. No secretarial, clerical, data processing, finance, and accounting time is included. My best estimate is that Ms. Blunt Powell and Mr. Fisher have worked full-time from September of 1992 through the end of this month, working on nothing but this case.
Okay. This is weird. Usually you hear from the victims' families at these things. And all the prosecution did was submit letters from the family, and now they're arguing about getting paid. This is bizarre. Okay, I'm going to move right on to the sentencing. It's weird. You don't need to listen to them argue about how much they're going to get paid. Jeez.
You ready to proceed? Stay ready to proceed. State prepared, Your Honor.
Dispense with the prayers.
Call the case of the state of Florida versus Danny Harrell. What I'd like to take up is to announce that the sentencing order that's going to be imposed by the court, copies will be provided to the media immediately upon adjournment of court in the respective meeting rooms. The second matter is that there was previously filed a sentence that contains paragraphs him statement of those matters that were previously raised in the record, either before or during the penalty phase proceedings. As to each of those, the court has in written oral order maybe findings on the record. I will tell you that it is still my intent on the issue, or I simply haven't had time to do it. Excuse me, so as to all other matters, the court's for regarding penalty phase proceedings. Now, as to those counts of the indictment that are directed to non-capital offenses, as the state, can I see it, please? Yes, Your Honor. Mr. Kearns, have you had an opportunity to see these, or do you wish to check?
We have reviewed the score sheet as the appropriate, or written the text contained on the score sheet, Your Honor, and we have no objection as to.
Also found certain victim notifications as you information report.
And those notifications are as to each of the individual counts. Having already been adjudicated to be guilty of all the counts contained in the indictment, the first thing I wish to do is to impose a sentence as to those non-capital counts. I would ask that the defendant's counsel be advised, please. Duly consider the arguments and the evidence. Finds it appropriate to sentence you as follows on counts 6 through 11 of the indictment returned in this cause by the Alachua County Grand Jury, and to which you have entered your plea. As to count 6, that allegation of sexual battery with great force as it relates to the victim, Christina Powell. The court has considered the guideline score sheet. It recommends a life for that offense. As to count 9, of that indictment, that being the residence of Christina Powell and Sonia Larson. Likewise, in that sentence, it is a first-degree felony punishable by life, and the court is imposing a life sentence on you announced as to count 6. Now, as to count 7, that is the allegation of sexual battery as it relates to the victim, Krista Hoyt. That is a life felony. The court imposes life upon you in accord with it. As to count 10 of the indictment, that count charges armed burglary of a dwelling with a battery on the residence of Krista Hoyt. Likewise, as the court on that one, a first-degree felony punishable by life imposes as just announced in count 7. Both of those sentences are to run consecutive to the life sentences announced in count 6. Count 8 is the allegation of sexual battery with great force to which you have entered your plea as it relates to the victim, Tracy Paulus. That is a life felony. As to that count, and under the guideline score sheet, I sentence you to life in the Division of Corrections. As to count 11, which is armed burglary of a dwelling with a battery, that being the residence a burglary of the residence of Tracy Paulus and Manuel Taboto. The court likewise sentences you to life for that first-degree felony punishable by life. Such sentence to be run concurrent with that sentence previously. Any other matters as it relates
relates to those particular campuses.
Not at this time, sir.
Then you may be seated. Thank you. There have been raised before the court issues in the nature of costs, liens, the investigative costs by various agencies, and certain matters of restitution claimed on behalf of the next of kin of these victims. As to those matters, there have been certain arguments made. The court has and does impose those statutory costs that are set forth 960.20, 943.25, two various sections of that control at 27.3455. Those are the normal costs imposed in a felony case in the state of Florida. The remaining matters are brought up under the restitution statute, under the victim's rights statute, and under Chapter 93901, and those chapters dealing with public defender liens. Those matters will take a ruling by the court concerning the imposition of the appropriate amounts based on evidence that is presented to the court. They will also take, as to certain aspects of them, at least an argument as to whether or not the court must determine the defendant's present ability to pay. So as it relates to those matters, it is my intention, and both counsel acquiesce, to set a separate hearing on the issue of restitution, those other costs, and matters that I've just announced, and basically hold a testimonial hearing where both sides can present whatever evidence you want. Is there any objection by the defense?
No objection by the defense. None of the state, Your Honor.
I would tell you that as to the issue of cost, to impose costs and rest, but I need to have the defense both noticed exactly what they are to defend against and give the defendant an opportunity to be heard.
Your Honor, for the record, the state announced that it is now with the court serving a motion for judgment of costs, a motion for judgment for costs, and a motion for restitution. Those will all be matters that will be heard in the hearing that you just directed to be conducted. We will, of course, notice both his counsel and him as to the time and date of that hearing.
That's correct.
Your Honor, we approach on a no different issue. Yeah.
But I haven't checked.
Letter is sitting in that courtroom right now. Why didn't they just let them speak?
The one matter the state asked for
That
clarification
courthouse
on,
is.
it's a form on the sentencing order itself, but I should announce it. The state is correct. The sentence is imposed, the 6 sentences just imposed are to run consecutive to any sentence now being served by the defendant in the Division of Corrections. Let me proceed to impose sentence on counts 1 through 5 of the indictment of this cause. In accordance with the Florida law, such an order, and will now publish it and file the original in the record, and I have copies available for both the counsel, for the defendant, and the state at the close of the announcement of the order. Committed in Gainesville, Florida. 2 of the victims, Sonia Larson and Christina Powell, were killed in their apartment in the early morning hours of August 24th, 1990. 2 nights later, the 3rd victim, Crystal Hoyt, was killed in her apartment, were killed in an apartment which they shared. As a result of these events, the defendant was indicted on November 15th, 1991. 5 counts of the indictment charge the defendant with the crime of murder in the first degree. 3 counts charge the defendant with the second crime of armed burglary of a dwelling with a battery. On June 7th, 1992, the defendant entered a plea of not guilty to all charges. Following lengthy pretrial discovery and investigation, trial was scheduled for February 1994, with jury selection to begin on his plea, and entered a plea of guilty to all counts of the indictment. The court accepted the plea and adjudicated the defendant guilty on all counts. On the following day, the court began selection of an advisory jury to determine the issue of imposition of penalty on 5 counts of first-degree murder. The jury was sworn on March 2nd. Evidence of aggravating and mitigating circumstances were presented to the jury from March 7th to March 24th, on which date the jury returned its advisory verdict. On each of the counts charging murder in the first degree, the jury recommended by a unanimous verdict that the defendant be sentenced to death. A subsequent hearing was held on March 29th, at which time the court heard further legal argument from the parties. Sentencing memoranda from counsel for the state and from relatives of the victims were submitted to the court. These letters have been placed in the record, a factor which is not found in the statutory list of aggravating circumstances. Therefore, the court has not read the letters, nor has not considered them in the determination of the sentence to be imposed. The court, on the evidence presented in the argument, the defendant was previously convicted of another capital felony or of a felony involving the use of threat or violence to some person. With respect to this factor, the court finds that the following offenses. As to each of the 5 capital counts in the indictment, the defendant has entered a plea of guilty to and has been adjudicated guilty of the other counts in the indictment, each of which involved either another capital other than the victim named in the count of the first degree murder to which the contemporaneous conviction is being applied. Prior offenses. The defendant has been convicted of a number of felonies involving the use of threat or violence to some person prior to the offense charged in this indictment as follows. 1. In 1976, the defendant was convicted in Hinds County robbery. 3. In 1980, the defendant was convicted in Montgomery County, Alabama, of the offense of robbery. 4. In 1991, the defendant was convicted in Marion County, Florida, of the offense of robbery with a firearm. 5. In count 1993 with a firearm. 1 count of attempted robbery with a firearm, and 2 counts of aggravated assault on a law enforcement officer. In 1990, that was managed to court. The capital felony was committed while the defendant was engaged in the commission of or attempt to commit or escape after committing a sexual battery or burglary. The court finds that this factor has been proved beyond a reasonable doubt with respect to each of the counts of first-degree murder in the indictment. At each of the 3 crime scenes, one of the victims was sexually battered prior to the murder of that victim. Each of the crime scenes involves a burglary, and at each of the scenes in which 2 victims, at least in part, in order to facilitate the sexual battery and murder of the other victim. 3. The capital felony was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The court finds that this factor has been proved beyond a reasonable doubt to apply in each of the counts of the indictment charging first-degree murder as follows. There are some facts which are common to all of the crime scenes, which show that this factor applies to all of the murders. This evidence shows that the defendant embarked on a series of murders as part of an overall plan, implementation of which began some weeks before the date of the first murder. On July 18, 1990, the defendant purchased a K-bar knife from the Army-Navy store in Tallahassee, Florida. The defendant stated that he had purchased this type of knife because it was designed for killing. It was a wide, strong knife that had a bloodline on it, a groove that runs longitudinally down the blade to permit easier penetration of and removal from a body. The defendant left Tallahassee on July 22nd and went to Sarasota, Florida, where he purchased a 9mm automatic pistol.
On approximately August the 18th, the defendant arrived in Gainesville, Florida. While in Gainesville, he purchased a tent and a camping mattress from a Walmart store. At the same time, he stole other items: a screwdriver, duct tape, 2 pairs of athletic gloves. The knife, the duct tape, the screwdriver, and the pistol were carried by the defendant to the crime. He carefully selected clothing suitable to his purpose. He dressed in black, wore a ski mask, and the athletic gloves. His professed reason for choosing black were 2: that it would be more likely to inspire terror in the victims, and that it would help him to avoid detection because blood turns black when it dries. The defendant's own words show that he had planned the murders in advance and that these activities were directed towards their commission. After the murders had been committed, law enforcement agents recovered an audio tape that had been made by the defendant prior to the first of the murders. The tape, begun by the defendant while he was in Sarasota and finished in Gainesville, contained a message directed apparently to the defendant's brother. On the tape, after discussing hunting and the proper way to kill a deer, the defendant made the statement, "There's something I gotta go do. I've got to go do." The defendant later confirmed to investigators that what he had to go do was to begin the series of murders. In addition, in speaking to a fellow inmate at Florida State Prison, the defendant stated that he planned to kill 8 people, 1 for each of the years of his prior incarceration. In yet another statement, the defendant stated that he committed the murders in order to terrorize the community, or in the words of his confidant, to become a superstar among criminals. Although the court cannot determine the defendant's motive, the defendant's words demonstrate intent and planning. In addition to the facts which are common to all crime scenes, facts unique to each of the individual crime scenes also prove that the defendant committed each of the murders in a cold, calculated, and premeditated manner. At the first of the crime scenes, the apartment in which the defendant murdered Sonia Larson and Christina Powell, the evidence proves beyond a reasonable doubt that the murders were committed in a cold, calculated, and premeditated manner. The defendant broke into the apartment. Although he was carrying the screwdriver, he did not use it to break into the apartment because the door was unlocked. He found Christina Powell asleep on a couch. He stood over her for a period of time, then went upstairs. He found Sonia Larson asleep in a bedroom upstairs. He took the time to evaluate which of the 2 he would kill immediately and which he would sexually batter and then kill. He decided to kill Miss Larson outright, then go downstairs to sexually batter and kill Miss Powell. He first taped Miss Larson's mouth shut with duct tape that he carried with him so that she could not call out. He then killed Miss Larson by stabbing her with the K-bar knife. The defendant descended the stairs. He taped Miss Powell's mouth with a duct tape and used the duct tape to bind her hands behind her back. He sexually battered her and then killed her with a K-bar knife. The circumstances of the murder at the second crime scene, the murder of Krista Hoyt, proved beyond a reasonable doubt that this offense was committed in a cold, calculated, and premeditated manner. The defendant went to the apartment of Krista Hoyt on the night before he committed the murder and observed her through a window of the apartment. On the night of the murder, dressed again in black clothing, ski mask, and gloves, carrying the screwdriver, the duct tape, the knife, and the gun, he returned to her apartment while she was absent and used the screwdriver to pry open the glass door. He moved a bookcase in the apartment so that he could stand in an alcove, a hidden position from which he would be able to watch his victim approach and from which he would be able to surprise her as soon as she entered the apartment. When she entered the apartment, the defendant attacked her, forced her to the floor, then used the duct tape to gag her and to bind her hands behind her back. He placed her on a bed and forcibly removed her clothing. He played with her for a fairly long time and sexually battered her. He finally turned her over and killed her by stabbing her in the back. The evidence of the circumstances of the murder at the crime scene proves beyond a reasonable doubt that these offenses were committed in a cold, calculated, and premeditated manner. Prior to breaking into the apartment occupied by Manuel Taboda and Tracy Paulus, the defendant first observed Miss Paulus by looking in through a window. As at each of the previous scenes, he was dressed in black, was wearing the gloves and ski mask, and was carrying the screwdriver, K-bar knife, duct tape, and pistol that he had earlier acquired. At one point, while he was observing his intended victim through the window, he had to hide to avoid detection by passersby. The defendant broke into the apartment through a double glass door by using the screwdriver. He went upstairs and found Manuel Taboda asleep. He realized he would have to kill Mr. Taboda to get to Miss Paulus. For some period of time, the defendant deliberated whether he should go through with his plan. He evaluated his chances, decided to proceed, and attacked Mr. Tabota. After killing Mr. Tabota, he chased Ms. Paulus to her room, broke down the door in order to get to her, and when asked, "You're the one, aren't you?" replied that he was the one. The defendant taped against his mouth and hands, and then to secure the curtain so that no one would be able to look in through the window and observe him. Our knife. He left the apartment, having been in the apartment for approximately 3 hours. At that point, having accomplished his objective, he buried the knife and based on the factors common to all of the murders, as well as the factors that are specific to each of the individual murders, the court finds beyond a reasonable doubt that all 5 of the offenses were committed in a cold, calculated, premeditated manner without any pretense of moral or legal justification. 4, the capital felony was especially heinous, atrocious, or cruel. The court finds that this factor has been proved beyond a reasonable doubt to apply to each count of the indictment as follows. There are facts which are common to all the crime scenes which show that all of the offenses were committed in a manner that were especially heinous, atrocious, or cruel. All of the offenses were committed of the night. The attack dressed in black and ski mask, factors which sized his identity and inspired terror in his victim. The offense were all committed by stabbing the victims to death with a knife. In addition to the facts which are common to all of the crime scenes, facts also prove that Sonia Larson was killed in her own bed by multiple stab wounds. There were 11 stab wounds of the right arm, 4 of which went completely through the arm. There were 5 deep stab wounds on the right breast. Another stab wound was found beneath the left breast. Still another slashing wound was found on the anterior surface of the left thigh. The attack was characterized by the medical examiner as a blitz attack, after which the victim would have remained alive for a period of from 30 to 60 seconds. Despite the relative shortness of the event, the fact that many of the wounds were characterized as defensive wounds indicates the victim was awake, shut so that she could not cry out. The murder of Christina Powell was committed in a manner that was especially heinous, atrocious, or cruel. In addition to the factors common to all the murders, the defendant first bound this victim, taping her hands behind her back. He forced her to perform oral sex upon the defendant. She was forced to perform oral sex upon the defendant. He cut her clothes off, taped her mouth, and sexually battered her. During this time, in the defendant's own words, she was terrified and would do whatever he wanted her to do. His intent to inflict unnecessary and prolonged suffering is shown by his taunting of the victim during the sexual battery. When she evidenced pain during the sexual battery, he told her to take the pain. According to the defendant, he kept her alive for a fairly long time. Finally, he killed this victim by inflicting 5 stab wounds. The nature of the wounds was such that they did not cause sudden death, but the victim remained conscious for a few minutes after being stabbed. At the second crime scene, the apartment of Krista Hoyt, the defendant attacked Ms. Hoyt when she entered her apartment, seized her, forced her to the floor, and immediately taped her mouth and her hands. After she had been subdued, he moved her to a bed, and in his words, played with her for a fairly long time before sexually battering her. In this play, he removed a tampon from her vagina. He inflicted a superficial knife wound of approximately 1/2 inch on her left arm. Finally, he turned her over on her back and inflicted the stab wound from which she died. At the last of the crime scenes, the murders of both Manuel Tabota and Tracy Paulus were proved beyond a reasonable doubt to have been committed in a manner that was especially heinous, atrocious, or cruel. The defendant, after deciding that he would kill Mr. Tabota, attacked him as he slept. The victim was awakened by a knife wound to his abdomen, going upward into his chest. As the victim, awakened by the pain of the initial wound, struggled to defend himself against the attack, the defendant inflicted multiple stab wounds. Many of the wounds were defensive. There were 31 cuts and stabs on Mr. Tabota. They included a slash of the chin, a stab wound of the neck, a grouping of 11 stab wounds and cuts in the upper mid-chest, a large stab wound in the upper abdomen, a slash on the right thigh, and 2 cuts on the lower right leg below the knee, as well as cuts and stab on the left wrist and both hands. The medical examiner described many of these wounds as defensive wounds, especially those on the hands and wrists. Both the photographs of the scene and the testimony of the defendant demonstrate that Mr. Tabota struggled vigorously against the defendant's attack. In such a situation, he would have suffered the pain of the multiple wounds. The murder of Tracy Paulus was committed in a manner that was especially heinous, atrocious, or cruel. Ms. Paulus learned of the defendant's intrusion into her apartment by hearing the noise of his struggle with Mr. Tabota. She went to Mr. Tabota's room, saw what was occurring, and saw the condition of the scene. She fled from Mr. Tabota's room into her own and closed the door. The defendant chased Ms. Paulus to her room, broke down the door, entered the room, and subdued her. Earlier in the evening, in a conversation with a friend, Ms. Paulus had learned of the other murders committed in Gainesville and expressed concern at that time that Mr. Tabota had not yet returned from work. She asked the defendant if he were the one, and he responded that he was. The defendant then taped her mouth closed, bound her hands behind her back with duct tape. He sexually battered her and then killed her by stabbing her 3 times in the back with a K-bar knife. As with the other sexual battered victims, he kept her alive a fairly long time before killing her. Because none of the wounds struck significant internal organs, the victim died from exsanguination, a death that would have taken some time. She would have remained conscious from 2 to 5 minutes after the wounds were inflicted. Based on these factors common to all of the murders, as well as the factors that are specific to each of the individual murders, the court finds beyond a reasonable doubt that all 5 of these offenses were especially heinous, atrocious, or cruel. The court has reviewed the other statutorily enumerated aggravating factors and find they do not exist. More specifically, the state requested that the court instruct the jury on the aggravating factor of witness elimination as to the deaths of Sonia Larson and Manuel Tabota. The court ruled that this statutory aggravating factor was not applicable. The court did not instruct the jury nor allow argument on this factor. The court has not considered it in the imposition of this sentence. Statutory mitigating factors. The defendant has no significant history of prior criminal activity. Based on the defendant's criminal record, as already stated, the court finds this factor does not exist. The victim was a participant in the defendant's conduct or consented to the act. The court finds this factor does not exist. The defendant was an accomplice in the capital felony committed by another person, and his participation was relatively minor. The court finds this factor does not exist. The age of the defendant at the time of the crime. The court received testimony from 5 mental health experts, 3 called by the defense and 2 called by the prosecution. All the experts agree that the defendant suffers from mental disorder, although they differ in their opinion as to the precise nature of the disorder and its severity. The defendant, born in 1954, had a chronological age of 36 at the time of the offenses. However, the testimony from the mental health experts, as well as from the defendant's family and friends, shows that because it was stunted by childhood physical and emotional abuse and his growing up in a dysfunctional family, the defendant's emotional maturity is that of a person approximately 15 years of age. As a result, the defendant lacks impulse control and the ability to relate to others as a mature adult. There is, however, no evidence of brain damage or mental retardation. His intelligence quotient is within the normal limits. Based on this testimony, the court finds that the emotional age of the defendant at the time of the offense is a factor in mitigation and accords this factor slight weight. The capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. In addition to the lack of emotional maturity, or perhaps as a concomitant factor, the defendant has some form of mental disorder was recognized by all of the experts. The experts differed as to the severity of this disturbance and to the extent of its effect on the defendant's actions. Its classification by the experts ran from severe borderline personality disorder to antisocial personality disorder with some traits of borderline personality disorder. Testimony established that the disorder is chronic. The defendant was under the influence of this mental disorder at the time of the offense and remains under its influence. There is significant disagreement, however, as to whether the extent of the mental illness is so severe as to be extreme under the statutory meaning of that term. Weighing all the testimony, the court finds that this factor has been established and that it should be afforded substantial weight. The defendant acted under extreme duress or under the substantial domination of another person. There is no evidence that the defendant acted under the domination or in concert with any person or acted under duress from any external force. Therefore, the court finds this factor does not exist. The capacity of the defendant to appreciate the criminality of his conduct and to conform his conduct to the requirements of law was substantially impaired. All experts agree that the defendant's capacity to appreciate the criminality of his conduct was unimpaired by his mental disorder. There is disagreement among the experts, however, as to the extent to which the defendant was able to conform his conduct to the requirements of law. All agreed the defendant had some capacity to control his conduct, and that his capacity to control his conduct in the presence of external controls was not affected. There was disagreement as to whether the defendant could conform his conduct to the requirements of law in the absence of such external controls. However, at times when external controls were not present, such as the time when he was making the decision as to whether he should sexually batter Miss Larson or Miss Powell, and the time when he was deciding whether he should proceed to attack Mr. Tabota, he was able to rationally evaluate his situation and make reasoned choices. Analyzing the testimony of the experts in the light of the facts of the offense, the court finds that although the defendant's ability to conform his conduct to the requirements of law was impaired, that impairment did not rise to the level of being substantial and is therefore not a statutory mitigating factor. However, the court has considered the defendant's mental capacity further as a non-statutory mitigating factor. It will be discussed again under that category. Non-statutory mitigating factors. The defendant's family background, including the fact that he came from a dysfunctional family, and the physical and mental abuse he suffered as a child are advanced by the defendant as non-statutory mitigating factors. The court agrees and has considered them as such. The evidence, particularly that received from family members and friends, made it clear that the court finds that the defendant was a product of a dysfunctional family and that he suffered physical and emotional abuse during his childhood. The court gives each of these factors significant weight. In addition, the court believes that this background contributed to the defendant's mental condition at the time of the offense, which the court has also considered as a non-statutory mitigating factor in paragraph 5 below. The defendant submits as a non-statutory mitigating factor that the defendant cooperated with law enforcement officers, gave a confession in which he admitted committing the crimes, and entered a plea of guilty to all counts of the indictment. The court is well aware that by doing so, he saved the criminal justice system time and expense. The court finds this factor exists and gives it moderate weight. The defendant, in his remarks to the court at the sentencing hearing, stated that he wished he could take back his actions and regretting the suffering he had caused. The court finds that this factor of remorse exists to some small degree and accords it slight weight. The mental illness of the family members is submitted by the defendant as a non-statutory mitigating factor. That there is a history of mental illness in the defendant's family was established by the evidence, and the court finds it exists. The effect of that factor on the defendant, however, is speculative. The court therefore finds that the factor exists but affords it slight weight. The court has also considered the effect of the defendant's mental condition on his capacity to conform his conduct to the requirements of law as a non-statutory mitigating factor. As stated more fully before, all experts agree that the defendant suffers from a mental disorder. Their testimony is in conflict with respect to its nature, its extent, and its effect. The defendant has an IQ within normal limits, although his mental age is approximately that of someone who is 15 years old. He therefore lacks mature impulse control and ability to relate to others. He was raised in a dysfunctional family and throughout his childhood was a victim of physical and emotional child abuse. The defendant's resultant mental condition was labeled variously as borderline personality disorder, antisocial personality disorder not otherwise specified, and described as having obsessive, compulsive, antisocial, and histrionic traits with elements of narcissism. His illness early showed itself through voyeurism. It is chronic, although it varies from time to time in severity and effect. His ability to control his actions and to conform his conduct to the requirements of law is impaired by the illness, although, as stated before, the impairment does not rise to the level envisioned by the law as substantial. Conforming his actions to the requirement of society is, for this defendant, more difficult than for individuals not affected by the illness, but it is not impossible. He does not suffer from a psychosis. He is in touch with reality. He can appreciate the criminality of his actions. He knows the difference between right and wrong, and he does have the ability, impaired though it may be, to choose the right and to adhere to it. The court therefore finds that the impairment of the defendant's ability to conform his conduct to the requirements of law because of his mental disorder is a non-statutory mitigating factor. The court has considered as such and affords it moderate weight. The court has very carefully considered and weighed the aggravating and mitigating circumstances as they relate to each conviction of first-degree murder as set forth in counts 1 through 5 of the indictment, and is being ever mindful that a human life is at stake in the balance. The court finds, as did the jury, that the aggravating circumstances outweigh the mitigating circumstances as to each of the first-degree murders in this case. Accordingly, will impose sentence. Mr. Rawling, if you and your counsel would rise. Accordingly, it is ordered and adjudged that the defendant, Danny Harold Rawling, is hereby sentenced to death for the murder of the victim.
Oh.
I do not want any more outbursts.
Whoa.
Ordered and adjudged that the defendant, Danny Harold Rawling, is sentenced to death for the murder of the victim, Sonia Larson, as charged in count 1 of the indictment. It is further ordered and adjudged that the defendant, Danny Harold Rawling, is hereby sentenced to death for the murder of the victim, Christine Pack. It is further ordered and adjudged that the defendant, Danny Harold Rawling, is hereby sentenced to death for the murder of the victim, Krista Hoyt, as charged in count 3 of the indictment. It is further ordered and adjudged that the defendant, Danny Harold Rawling, is hereby sentenced to death for the murder of the victim, Tracy Paulus, as charged in count 4 of the indictment. It is further ordered and adjudged that the defendant, Danny Harold Rawling, is hereby sentenced to death for the murder of the victim, Manuel Tabota, as charged in count 5 of the indictment. The defendant is hereby committed to the Department of Corrections of the state of Florida for execution of this sentence as provided by law. May God have mercy on his soul. Done and ordered this 20th day of April, 1994. Mr. Rawling, your counsel has also informed me that you had a request concerning a particular recommendation or order by the court concerning particular housing in the division. I cannot do that because I do not have the authority to tell the division where to house you. And secondly, the factors that are considered as to where a particular inmate should be housed are matters left to the executive branch, and I should not interfere with that. And out of respect for them, I won't. You having been so sentenced, I remand you to the custody of the Division of Corrections. Order that no one is to move in the courtroom until Mr. Rawling has been removed by the Division of Corrections.
5 years. You're going down to 5. Understand that? In less than 5 years.
Mr. Snowden, remove Mr. Tabota from the courtroom, please, sir.
You.
Mr. Tabota, please remove yourself from the courtroom, sir. Please.
Justice is
Please.
between these walls. We have the last say. We will prevail. Our children's names will be remembered over him. I will ridicule him.
Ladies and gentlemen, I'm sorry for that. Other than that, the proceedings have been done, I think, appropriately. With that, I thank you for your conduct, and this court is adjourned.
Court adjourned.
Whoa. Where am I? There I am. I guess that was Manny's dad. Dang. I mean, he could have been a lot worse. I don't blame him. Okay. In a little less than an hour, I've got another live stream set up. Because why? Because I want to talk about the Ashley Benefield motion for a new trial. Did I try to record it again? I think I tried to make another recording. I don't remember. I don't remember why it didn't work again. I'm just having trouble recording it for some reason. It's not working out right. So I'm going to do a live stream. So please show up at 12:30 so I'm not talking to myself. I don't know why I can't get it recorded right for some reason. I don't know. Every time I try to record it, something happens. So if something happens while I'm doing a live stream, I'm going to look like an idiot. But I'm going to try to live stream it at 12:30. So, and I don't know how to do the redirect thing. But I could try to learn how to do it. I think I read somewhere that you go to YouTube Studio. And then you click on content. And then live. And you hover over the video that you want to go from. And then you click on edit. And I don't see an edit button. Oh, wait. I didn't hover. I clicked. Doesn't say click, it says hover. Hover. I'm hovering. It's not doing anything when I hover. Well, that didn't work. Is it because I'm not monetized? I don't have that feature. It doesn't say redirect when I hover over anything. They lie. Oh, well. You guys will just have to show up. I have no idea. I did learn how to pin posts, though. I don't know if you noticed yesterday I was pinning posts at the top. Oh, probably. I don't know. And I learned how to do, I was watching Brandy Churchwell yesterday because we were waiting for the verdict in the Robert Tellis case, and I noticed how she had this nice little cute little border around her. And, you know, Legal Wise has one, EDV has one, and I was like, how do you do that? And then I was just playing around with StreamYard, and I was like, oh, cool, purple. So I need to figure out how to make the cute overlays and do all that kind of cool stuff. But, I mean, that's just secondary. Your content's what's important, right? So, okay, so I'll see you guys at 12:30. Okay? No, they didn't ask for the death penalty in the Tellis case. He got life with the possibility of parole in 20 years. And I think what they did, because it was 3, see, in Nevada, which is kind of strange, I think, the jury picks the sentence. So they had 3 to choose from: life without parole, life with possibility of parole in 20 years, and 50 with possibility of parole after 20 years. And he's 48 now. So even 50 years is a life sentence, because like 50 years will be 98 when he gets out. But Brandy said like she thought they split the baby because they did life with possibility of parole after 20 years. So in 20 years he'll be 48, 58, 68, so he'll be almost 70 in 20 years. But the guy thinks, I don't know if he thinks, I think I hate to, I don't know. I'm worried about what I say on here now, but he said the whole thing was a conspiracy, that he was set up by the cops and by a real estate agency, and I don't know. But he says he got up there on the stand and he did a narrative because his lawyers, I guess, didn't want to suborn perjury, so they just let him get up there and talk. So he's never going to admit to a parole board that he did it. Like, to get parole, You have to say, I did it. I'm sorry I did it. I'm remorseful that I did it. I will never ever do anything like that again. I'm sorry for the victim. You know, like, you have to be remorseful. They don't just give you parole because you've been good in prison. I mean, that factors in, but you also have to be remorseful for what you did and admit that you did it. And if you don't get parole. No, he wasn't pro se. But from what I've been told, what I've heard is that when a lawyer is representing a client that is gonna that wants to testify against their well, all defense. My nose keeps itching. I don't know why. When usually an attorney will tell their client not to testify. So if a client testifies, it's usually against the advice of their lawyer. But if they're going to get up there and lie and say they didn't do something that they did, well, an attorney can't let their client get up there and lie. They can't suborn perjury because that's illegal. So if they get up there and they ask questions and their client is lying, the answer to the question is a lie, and the lawyer knows that, he's suborning perjury, and he can get in trouble for that. So when they know their client's going to get up there and lie, they don't ask any questions. They ask the judge if it's okay that he testify in the narrative. And then they get up there and then they just testify. They just talk. So that way the attorney is not suborning perjury. And that's... Oh yeah, the Sandra Birchmore case. Yeah, I heard about that one too. That one's disgusting. That is just flat out disgusting that they did that to that poor girl. And her poor mom, she died in 2016. I don't know when Sandra died, but her mom didn't get to see justice being done. The police in Canton are stupid. Not everybody in Canton is stupid, because have you watched some of those town meetings? The citizens of Canton, they're up in arms about all this stuff. Like, Canton needs to fire all their public officials and start over. That's what Canton needs to do. Just fire them all and start over. So, yeah. So, Brandy said that in Tellus's case, they split the baby because I don't know. I guess maybe because he had kids. And, you know, a lot of the witnesses were like, he's a good father. He deserves to get parole one day so he can have time with his kids. Well, you know what? Jeff Gurman doesn't get time with his nieces and nephews. He didn't have kids, but he was an uncle, and he spent a lot of time with his nieces and nephews. He doesn't get time with his nieces and nephews anymore. You know, Tellus still gets time with his family, even if it is just letters from jail. He still gets time with his family. I'm sorry. I mean, if you kill somebody, that's it. They don't get anything anymore. And you still get stuff when you're in prison. That's why I'm with Just Because. Like, life in prison is worse than the death penalty. But at the same time, they still have a life, whereas a person that they killed doesn't. So, like, I go back and forth. Yes, it's horrible to spend the rest of your life in prison. Yet, you still get a life. And eventually, you're going to conform to that life. You know what I mean? Like, it's going to become your normal, and you're going to learn how to live that way. Oh, yeah, Sarah Boone. I cannot wait till that trial starts. I'm going to do a video on her because I know for sure I'm going to stream it now because Alita's not going to stream it. She told me to go ahead and stream it. She's not going to stream it. So I need to make a video on her. That's going to be a long video. I'm going to have to go through all those hours of interrogation and everything. And so it might be next week before I get it out. But I'm going to do a video on her. I don't know whether I should include all the pre-trial hearings and everything. I guess I need to, since she's going pro se. I guess I need to follow the paper trail, as they say, of all the lawyers and everything she's gone through. Oh, I think the channel's called Course Again. She briefly went over the motion to dismiss like I did yesterday. Basically did the same thing I did. Was like, what the heck? So, I don't know. I sent Peter a DM on X yesterday. No, he did not DM me back. To be honest, Peter has never DM'd me back when I have DM'd him. So, don't know why. I can't be in 2 streams at once. I don't know why. I have enough trouble modding and following a trial at the same time, like in the same stream. I miss so much stuff during a trial when I mod. So when I watch a trial on Alita's channel and I'm modding, I always watch her recaps because I miss stuff. Okay, well, I need to take a break and make my lunch and everything before we go to the Ashley Benefield motion. So I will see you guys at 12:30. Bye.